Today is a day of a tale of tales that the world know very well. But to them that the story is told about forever remains a tale. But on this joyous day of days, what was lost have now been found. Them who helped to uncover the truth will live in the world renowned. Return of the King, return of the King, make way, make way, make way. Return of the King, return of the King, forever where he may reign. Time waits for no one, 'cause everyone's subject to time. From tales of God to tales of men, therein your answer will lie. Return to the King, return to the King, make way, make way, make way. Return to the King, return to the King, forever where he may reign. Greetings, 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 greetings. It is I, your King. Greetings,
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 greetings
greetings once again. It is I, your King.
Is the screen shaking like that?
Yes.
I don't know what's going on. All right, let me just put myself on. All right, let's try it again. Greetings, 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 greetings. It is I, your King. King Clifford Jefferson, ascendant of God for the fifth kind of Banju, son of the fourth ruler of Jerusalem. I'm here today on behalf of our ancestors. Can everybody hear me?
Yes.
Everybody hear me just fine?
Yes, we can hear you.
This is Echo.
Okay, all right. Once again, I apologize for my screen, but I'm gonna move forward. Greetings to you all. We're here today on a marvelous lesson. I'm pretty sure we had a long break. Hope everybody had the time to deal with their situations. In lieu of that break, we know that time is very important for us, but once again, we're glad you're here again today. My screen is acting up. Unfortunately, you might not be able to see me, but I apologize for that. But thus far, we're going to continue to move forward. I have a marvelous lesson created for you. This lesson that I have prepared is in lieu of Prince Patriarch, Father of the Nation. And this lesson is tell it for all those who are less fortunate, those who are subject to what we call social welfare or social security, or any type of social assistance that's given by the so-called present administration. And a lot of it's given with a lack of knowledge of the origin why it's given. And as a result of it, we're subject to the encumbrances that comes along with the benefit. We have a lot of forms out there today, you know, that a lot we don't see, a lot we do see. And a lot of the forms that out there try to cover the topics that's covered these agenda that we're subject to as far as the administration set up by the so-called residing government. And government is now in question. And it had always been in question, especially for us in light of our situation. And it's not a light situation, it's a grave situation. So unfortunately, you won't be able to see me, but the lesson you will. I hope that everyone who's here today and present understand how important this lesson is today in lieu of everything that has been said before today, in lieu of the previous lessons. One thing I need everybody edge in your mind, and I want everybody to say it, that positions, parties may change, but positions don't. Everybody say it for me.
Parties may change.
Parties may change, but positions don't.
Say it again. Parties may change, but positions don't.
Parties may change, but positions don't.
That's very important because it all denotes to a contract, an agreement. And there's only two positions, the grantor and the grantee. These are two fixed positions, the grantor and the grantee. And that can be any situation, any type of situation. It can be working at Dunkin' Donuts. It can be selling your car. But to us, all that is created by the use of the land. And that falls into the position of the two, the grantor and the grantee. None of the contracts that are present in this form of government or any government that exists today deals with the original origin of the contract that goes back to the concept of the grantor and the grantee. The grantor and the grantee, and the positions are self-explanatory. We know that the grantor is the one who gives something. He has full parcel. Something that he gives to a grantee is called subdivided parcel, which is called for a purchaser. Somebody's purchasing something. You become a grantee, you're getting something. This is very important because most of the people in regards to the administration that we're subject to on the federal, state, or municipal level, or any level that may exist under our consciousness, we're always subject to what position? The grantee. We're always in the position of the grantee, as we're giving something from the grantor. And for the grantor to give something away that belongs to him would be stupid. Why would the grantor give, especially the topic land? This is the topic, because everything that goes on the land, it's called land use. The use of the land, for what reason it may be, is for the purpose of the use of the land. The land use is the management, the modifying of the natural environment, the wilderness, for settlement. And we know what settlement means, to occupy. And that's based off land use regulations, and is governed under the present administration that allowed it to do it. And in order for that to happen, that administration must have authority under what we call land use regulations. Because they set up shop in the buildings, the fixtures that are attached to what we call the land. And there should be only one landlord. Because we're dealing with the land, then we deal with going to the topic of who was the original owner of the full parcel of land. Not from an abstract point of view, from a concrete point of view. And for that, you have to get into the origin of what we call the charter. Charters. The charter is an instrument that has official authority that's granted by somebody, a grantor. If somebody takes the place of a grantor, if a grantee takes the place of a grant, if a grantee takes possession of a grantor, and that's not be in detail in the instrument based off the grant, then it's either based off either two things, fraud or mistake. Fraud or mistake. In our case, it's fraud. Because we know that the original grantor of a parcel of land in our day and time goes back to who? The king or a monarch. So in order for there to be a contract between a king and a monarch, because we know that everybody else was just based off land use, that goes back to the settlements, going back to the colonies. We already know that history. There must be an agreement, a contract, with a clause based off who's giving it, who's granting it, and the stipulations to that contract. In regards to the land, because everybody making claims to this land. If you made a claim, there must be a contract. And contracts are made in many ways. The one people don't look to is statutory contracts. A statutory contract. Because statutory is created by acts of legislation. By a quorum of people who exercise authority granted to them by the Constitution. Because the Constitution is an investing instrument. It invests power to those in commission who's operating on the land. So that automatically puts them in one category called the grantee. Everybody follow? That comes from what we call the grantor's doctrine, the common doctrine of the grantor. That's based off the grantor and the grantee coming with an established division of land. Based off what we call the description, a legal description of the estate in question. Whether it's if it's full parcel, that means that ain't no question because it automatically belongs to the original owner, the one who granted it. When it becomes subdivided parcel, then somebody's purchasing land. For whatever reason it is, they're purchasing land based off the stipulations as conformed by the grantor. So as we know, based off that language, there's a limitation already in place. There's a limited or encompassing clause that lets you know that whatever deed, whatever interest, whatever possession that you have in regards to the land is limited based off of being given to you by the grantor. Does that make sense to everybody?
Crystal.
Follow.
Unless there's a clause in it that the grantor surrenders all his interest and equity in the land, meaning he don't no longer have control over it. That's called subfeudation, being able to sell land that don't belong to you. That's what we're subject to now. That's what we're trying to fix. Because everybody is subject to what we call king, prince, patriarch, father of the nation. The father of the nation was the king. But when the king was dissolved and the house that he belonged to, which we now call Congress, something else was put in place to oversee us as in lieu of our social securities and our social welfare. This brings up the subject of the poor. Our brothers and sisters who are poor don't have no relief because there's nothing there in place to make sure that they're well taken care of. Because that was the obligation for the land use. Now I'm going to show y'all what nobody else have been able to show y'all because they're always been in the position of the grantee. And you can't have a bunch of grantees, but there can only be one grantor. Only one grantor. Parties may change, positions don't. In this case, we're talking about your commission. What gave you the authority to sit in the seat that you sit in? In this case, it's the legislation, the executive, and the judicial. The legislation governs them all. The executive executed and the judiciary opposed. But now all of them are out of whack because of those who created the administration. Because our administration was replaced with the governor. Our present governors of our present states are overseers. He's called the province patriarch. He passed it on to what we call the attorney general. The attorney general was appointed by who? The governor. The Attorney General is head of the judiciary on the state and federal level. Everybody follow?
Follow.
So the two main people that that needs to be addressed is the governor and the Attorney General. Because without checking them, the judiciary is running them up. They run them up. Everybody follow?
Follow.
If you missed this lesson, we need to understand that if it wasn't for me, because of this position, not the party, the position of a king. This is what we need to understand. His council is a position. It ain't distinctive of parties. It could be anybody, but it's the position that you hold. We need to understand this. Because I'm acting as patriarch, the father of the nation, because nobody can come to your rescue. The Attorney General can't do it, the governor can't do it, the president can't do it. I'm gonna show you what nobody else has been able to show you. I'm not just talking about it. I'm gonna show you in concrete form that you are doomed without me. You go look up King Clifford Jefferson right now in the district court, and I have a docket number for every issue that is addressing us as a nation of people. Right now. And by the ending of this podcast, I'm going to show you how we are fishers of men. I'm going to show you how you're kingfish. And in order to fish, you have to have good bait. And if you don't know how to fish, then whether you got good bait or good fishing pole, it don't make no difference. Because it's not the parties, it's the position of a fisherman. Everybody follow?
Follow.
When we talk about fishermen, we talking about one who's able to bring legal aid to those who are in distress, those who are out there drowning in the cares of the world. Those are the fishermen. I ain't distinct of the person or parties. It's the position that's in question. That's what I'm concerned about. Because our people who are suffering are drowning in the sea of laws that can't save them. And the one who enforces the law is the judiciary. The ones who created the judiciary was ahead of the judiciary is the Attorney General. And the ones who appointed them all is the governor. And no one's addressing this issue with the governor but me. But me. Because not just your family members are suffering from the cares of the world, my family members are suffering from the cares of the world. If I don't do nothing about it, who's gonna do something about it for them? We are put in an environment, as Archbishop said, because of the overseers' plan to keep us in the state of poor, because they're using our lands and every asset that belongs to it, because that's our state. And I don't know any other way to simplify but do this way. So with that, let's get started. Everybody ready?
Ready.
Ready to go, King.
All right. I'm gonna need some assistance right now. Countess Middleton. I'm gonna let you start.
All right.
1 second, let me put my screen up. Let me blow it up a little more so that people can see. Okay, everybody see that?
Yes.
Okay.
Yep.
Ready to be, Countess.
Yes. What is a meeting of the minds? The term meeting of the minds refers to an understanding or mutual agreement between two or more parties and their understanding of that agreement. In legal terms, the phrase denotes the essential element in the validation of a contract. A meeting of the minds occurs when both parties actually assent to a contract's terms. It may also highlight the time of a mutual agreement, although the acts of this agreement need not occur simultaneously. A subjective meeting of the minds was traditionally required when it came to the ascent of contract theory, but modern law dictates that a meeting of the minds must be objective. Key takeaways. The phrase meeting of the minds refers to the comprehension and mutual agreement of all obligations within a contract. A meeting of the minds is a critical element of a contract associated with acceptance and acknowledgement. It can be difficult to challenge a contract after a meeting of the minds occurs and is established. If contract issues, challenges, or court actions arise, it can be left up to the court to interpret the elements and language of a contract and its intentions. Ensure you negotiate the terms of your contract and consult a professional before you sign anything.
Okay, everybody understand that language? Nothing to talk about, right?
Right.
A meeting of the minds. A contract is agreement. An agreement is the instrument that shows that the contract between the grantor and the grantee was made based off the meeting of the minds, right?
Right.
Now, is your mind attached to your body?
No.
No.
Everybody who's watching this video needs to ask themselves, based off the so-called contract they have with the original grantor. You can call him God, Lord, Jehovah, I don't care what you call him. We can use an abstract term and still relate them to a time and era where the body can't go to, but the mind can. Does that make the difference? That's what we got to prove, that there was a meeting of the minds going back to what we call time immemorial. In order for our contract to be honored, right? Did that make sense to everybody?
Crystal King.
Yes.
We must have proof that both parties consented to this agreement of the meetings of the mind. Now, that's crazy to call it the meeting of the mind. It is a meeting of the brains. It is a meeting of the people. It is a meeting of the entity, corporation. It's a meetings of the minds. We know mind is what? Consciousness, right?
Right.
The consciousness is the awareness of what's going on without the body even being acknowledged in it. So if we're making a claim to the land, then we must prove that our minds goes back to the original meeting with the mind of the grantor. If you can't do that, you're in a world of trouble. Because you got to show how you got to be the grantee. We're not saying we're grantees. We're saying we're the grantors. Whatever I got, the king got, because the king gave it to me. Why? Because the king permanent patriarch. And everybody who worked for the king are the king's officer. So you hold an office, a position. Everybody follow?
Follow.
You're in a privileged condition. Everybody else ain't in the same condition that we all claim to be in, because you got to prove it. Not just to me, I'm only the vehicle for you to recognize that there's a claim to be made and you have a choice to decide what choice you will decide you on based off the meaning of the mind to the contract you saying you uphold it, and that you have a right to based off the terms and conditions of that contract, because the word contract means to get something. Y'all really need to hear what I'm saying. Countess Millicent just read the meaning of the mind. So let's go back to original contract, because all those who claim they come from Egyptian, Jerusalem, Muhammad, you need an actual contract that the parties who took over the contract as administrators over the contract and the assets that belong to that estate, which was left in the trust, by the original grantor for the intent that the grantees were using them, which was for the heirs. Because the original intent of any type of property for an heir is based off intel. And we know the intel land is crown land. I'm not just talking, I'm gonna prove it to you. I'm gonna show you from chief justices. All right, let me move forward. Please, y'all, please, y'all better hear what I'm saying to y'all today. I don't determine your salvation. You determine your salvation by way of fitting in this position. Because you can fake this position all you want and get caught out there. And I'm gonna show you, if the people who I'm about to expose got caught out there, then best believe I know your situation as well. I know your situation. You talking about Jesus? Look at me in the light of Jesus Christ. His purpose and intent for coming here. Look at this lesson through the eyes of that view of the symbolic meaning of him saying, I didn't come to change the law, but to fulfill the law. I'm fulfilling the law that these people who hid the law prophesied about. They prophesied about what's going to happen. Let's go there. A governor. Everybody see this?
Yes.
It says a governor, royal governor, colonial government, and the 13 colonies. Governor, governor general. These are all the definitions of what we call a governor. But it says a royal governor is a gubernatorial official appointed by a king or other monarch and may refer to colonial government in the 13 colonies. We follow?
Follow.
So any royal governor was a governor appointed by the king or a monarch. Whatever party was sitting in that position, it was a different party, i.e. person, but the commission was still the same. You king. Just like everybody else in the office, it's an officer. You play that role because the role entails that position. So we see the original role of a governor is one that was appointed by a king or a monarch, and that's by what we call letter pack. All right, let's move further. William Patterson. Anybody know who William Patterson was?
Second government of New Jersey? Or first governor?
Second governor.
Second.
Well said. Everybody see this?
Yes.
You can read Countess Middleton.
William Patterson was an American statesman and signer of the United States Constitution. He was an Associate Justice of the United States Supreme Court, the second governor of New Jersey, and a founding father of the United States.
Stop. So he was the Associate Justice of the United States Supreme Court. He was the second governor of New Jersey and the founding father of the United States. So he's not only recognized on the state level, but the United States level. We ain't concerned about the United States level because they didn't come into existence until you had the state level, because he was the governor of New Jersey. He replaced William Livingston. William Livingston was the first governor of New Jersey who replaced the last world governor, William Franklin. Everybody listening to me. Positions don't, parties don't change. Parties change, positions don't. Everybody drill out of your mind. Parties may change, positions don't. So William Patterson succeeded William Livingston, who succeeded William Franklin. But the positions that they both played were distinct. William Franklin was a royal governor. the last world governor, before the administration of the first Continental Congress took over by what we call William Livingston, which moved it from Perth Amboy to Trenton. He also said he was the second governor of New Jersey and the founding father. Read the next paragraph.
Born in County Antrim, Ireland, Patterson moved to the North American British colonies at a young age. After graduating from the College of New Jersey, now Princeton University, and studying law under Richard Stockton, he was admitted to the bar in 1768. He helped write the 1776 Constitution of New Jersey and served as the New Jersey Attorney General from 1776 to 1783. He represented New Jersey at the 1787 Philadelphia Convention, where he proposed the New Jersey Plan, which would have provided for equal representation among the states in Congress.
Stop. Okay. When we talk about the Jersey Plan, New Jersey Plan was the plan that came between what we call the Connecticut Compromise. You had the Virginia Plan and the Jersey Plan. The Virginia Plan was created by or authored by James Madison. The Jersey Plan was authored by William Patterson. They came together because of not wanting either plan and created what you call the Connecticut Compromise, which was the foundation for the United States government back in 1776. Do everybody hear me?
Yes.
Read the next paragraph.
After the ratification of the Constitution, Patterson served in the United States Senate from 1789 to 1790, helping to draft the Judiciary Act of 1789. He resigned from the Senate to take office as governor of New Jersey. In 1793, he accepted appointment by President George Washington to serve as an associate justice of the Supreme Court. He served on the court until his death in 1806.
Okay, so this second governor of New Jersey, who replaced the first governor of New Jersey, which was William Livingston, who succeeded William Franklin. William Franklin was a royal governor going back to the time in the position as established by Viscount Cornbury under Queen Anne, under what we call the Crown, or what we call the Provincial Congress. I'm parts of the Provincial Council before it became the Provincial Congress. It was called the Provincial Council that was under the authority of the Crown. So here's this second governor of New Jersey. He not only helped draft the Judiciary Act, where all your federal judges coming back, which was the first one appointed by Richard Stockton. Richard Stockton was the first Chief Justice appointed by who? George Washington. George Washington signed off on the Judiciary Act that was actually authored by William Patterson under the Judiciary Act of 1789, introduced by Richard Henry Lee. Everybody follow?
Follow.
So he is a pivotal player in this, what we call treasonous act, or what we call overthrow of the government, what they call a coup d'etat. What you call that term, Archbishop?
Coup d'etat.
Coup d'etat. This is a coup d'etat being uncovered by me. I'm gonna prove it to you. Because the United States Judiciary of 1789, going back to Marbury versus Madison, didn't have the authority of the King's Bench to issue any prerogative writ. That origin goes back to the King's Bench, which origin goes back to the Supreme Court of New Jersey, which I'll show you in a second. So that means everybody that are soon to be the founding fathers, which William Patterson was one, as the second governor of New Jersey, who replaced William Livingston, who came to be the first governor of New Jersey after William Franklin was arrested for trying to prolong the provincial council under the crown. He was called a loyalist or a royalist, or what we call the king's men. Everybody say that. The king's men.
King's men.
Remember, meetings of the mind. Nobody who came up under the administration of 1947, this includes their citizens in their physical capacity, their citizens in their public capacity, and their citizens in their private capacity. This is, you're limited as a grantee. So your liberty, rights, and securities are also limited. We're talking about if any states that got their authority from the union, you're automatically doomed. You're doomed. Because the United States don't have no authority, because the authority of the King's Bench was not prescribed in the Supreme Court, as we see in Marbury versus Madison. It was instilled in what we call the Supreme Court of New Jersey. And the first Supreme Court of New Jersey operated on what they call the courts of errors and the courts of appeals, which is called the King's Bench, which were made up circuit courts, orphan court, court of session, court of, what else? Chancery, what else? Courts of common pleas, courts of exchequer, what else? Star Chamber. These were all the courts that were here in New Jersey under the prior administrations that the United States administrations and the states administrations called into question, and I'm gonna show you in a second, all right? Because here we see George Washington, who had started everything on the federal level. William Livingston started everything on the state level in regards to New Jersey. And we know prior to that, there was no such thing as the United States, because at that time they were called United Colonies. And all the United Colonies were property of the crown. So they automatically put you in the status of a grantee. Not a grantor, a grantee. Because your mind don't go back as far as ours go. Our mind goes back to time immemorial. There's an agreement from time immemorial that exists till now. And I'm gonna show you that was put in place by way of the scheduling clause of all the constitutions that were amended to this present one, which we call now the 1947 Constitution. Okay, without further ado, everybody, any questions?
You said the Jersey plan was made by William Patterson, the Virginia plan by James Madison, which created the.
It was introduced
okay.
by William Patterson. If it wasn't for the New Jersey plan and the Virginia plan, you would have no United States. So that meant that the Jersey plan and the Virginia plan, now called the Connecticut Compromise, was a complete, how you say that term again? Coup d'etat, to overthrow the power that already existed here by way of the superseding of the Constitution, because the supersede the Constitution means replace the Constitution on what we call law reform. Now you got all types of law reform. You got law reform dealing with police, law reform dealing with what you call medication. We even got law reform dealing with prison. But the main law reform that should be dealt with is the land. Reformation of a deed. Reformation of a deed comes in when there's a deed in question to a land, and we know the land's in question because the limitation on a lay fee, I fee simple, was already limited by the terms and conditions of the grantor, as we said, the monarch. There is no monarch in place now, so that meant that the only people here based off the terms and conditions of a grant are grantees. Everybody understand? There is no monarch here yet until now. So everybody was playing the position of a grantee. No one wanted to entertain the question of the monarch, because when a monarch comes into question, it automatically calls in for what we call a king prerogative, which is called a prerogative writ. Record is a writ of circularity, which means to make certain the record to bring forth the questions in regards to the administrations. That means any administration that was formed. If you violate the rules, the king is able to call what his prerogative is, called a writ of circularity. The Supreme Court don't exercise that authority in Marbury versus Madison. New Jersey Supreme Court doesn't exercise that authority under Article 6, Section 5, Paragraph 4, which I'll show you in a second. But yet the King's Court still exists here under Article 6, Section 4, Paragraph 1. So if the courts are still here and the prerogative attributes of the king are still here, that means that the only person missing out of the equation is the king.
Mhm.
The king is the only one to call into question the administration and question what they do by what they call the other prerogative writs, which is called a writ of mandamus, writ of quo warranto, writ of quittance. I'll go through all that in a second. For the sake of time, we move forward. Everybody understand?
Crystal.
Follow.
Any questions? Okay. Let's look at a list of justices. I'm not just going to talk about them. I'm going to show you them. Our present Chief Justice of the Supreme Court of New Jersey is now Chief Justice Rabbit. Everybody see that?
Yes.
That's our Chief Justice right now. Under the 1947 Constitution, that's our Chief Justice. Our Chief Justice under the Administrative Procedure Act that was created January 14th, 1969, a year before I was born, under the Richard J. Hughes. He's the Chief Justice. He's the 45th governor of New Jersey and the Chief Justice of New Jersey Supreme Court, where our Supreme Court sits right now today in Trenton, New Jersey, which is all being questioned right now in the district court as a result of the positions that they play. I don't care about the parties, who's sitting there. I'm questioning the position in which you hold, because this is not the position that were put in place by the king. The United States Supreme Court just told me they don't have that authority. The Supreme Court of New Jersey told me they don't have that authority because of this Constitution of 1947. Prior to that, the Constitution of 1844 and 1776 was all based in the common law, going back to William Patterson, the second governor of New Jersey. Everybody follow?
Follow.
You have to know that to be a part of the King's Council, because this is part of your commission. Because everybody else is sitting in the commission without the authority to do so. And the only way you can call them out is by a prerogative writ, because guess what? The states and all its employees are immune under the Civil Rights Act of 1964, as well as the Civil Rights Act of 2004 of New Jersey. They're immune from suits. I'm gonna show you in a second. So if you come up under the Civil Rights Act, but come up under the Administrative Procedure Act, which is not a government, it's a business. I'm gonna show you. Okay, first Chief Justice and present Chief Justice Rabbit. Just travel back through time of the meetings of the minds, because we're concerned about what was on these minds of these people and these positions. Would y'all agree?
Agreed.
Agree.
We got to know what was on their mind, because that's where we meet and greet. You got to influence, because when they took that commission, it wasn't based off the original meetings of the minds of those who took that commission before them. Can we agree?
Agree with that.
Agree.
Those who sat in those seats before them was not following what they're following now. That's from the time of the United States as well as the time of the colonies under the crown. They're not following what was going back in that time. We're not worried about the parties. because the parties may change, the positions don't. If you ain't the right party and you sit in that position, chaos can come out of it. Everybody agree?
Great.
Agree.
That's what you're in now, chaos, because no one will want to sit in a position as authorized. And the only one can call that into question was the king by his prerogative, because the Supreme Court can't do it. The executive can't do it, nor the legislature can't do it. Because it exceeds the power as authorized by the Constitution. Because at the time of their Constitution, or any Constitution, the prerogative writ was authority granted by the monarch. Everybody understand?
Crystal.
Wow.
If there is no monarch, then that means that the position has changed because of some party sitting in that position de facto. This is the language that you must talk. Because my wife always told me, think of every reason that you can use, that they may use to get out of this situation. It's like fishing. She always say that. King, you've been at this for years. Think of every reason or situation that you may use, because you know them. We already know, based off, let's just follow them. Still rapping, let's go back in time. Richard Stockton. Now, didn't it say William Patterson studied law underneath this guy?
Yeah.
It said it. And he was appointed by George Washington, your founding father, who signed the Judiciary Act where this judge sits. Richard Stockton. Let's come on down. Now, this is the so-called United States who ain't even in existence right now. Because this is in reference to the United States, which didn't even come into fruition yet. They didn't come into fruition until 1787. So where did these justices come from in 1776? New Jersey. Let's follow the paper trail. All these chief justices, y'all. I don't care about the parties. All I care is the position. Supreme Court under 1947 Constitution. Arthur T. Vanderbilt. He was the first Chief Justice under the 1947 Constitution, which was amended from the 1844 Constitution and the 1776 Constitution of New Jersey. That was all dealing with those Chief Justices that preceded this guy. Everybody see that, right? Let's go down. How many is descended from? Arthur T. Vanderbilt, Albert E. Burling, Harry Hur, William A. Watchfield, A. Dayton Oliphant, Clarence E. Chase, Henry E. Atkinson, Nathan J. Lewis. All these were appointed by the 43rd governor, Alfred Driscoll. Everybody see that?
Yeah.
He was the 33rd governor of New Jersey. Do y'all hear me?
Here you can.
The second governor was William Patterson. The first governor was William Livingston, who overthrew the last world governor, William Franklin, who was sitting right here and Perth Amboy. I'll show you in a second. Alfred Driscoll, the 43rd. Robert Maynard, the 44th. The 45th, William, well, he was considered sitting. He wasn't really official. He was an actor. All these, we're going to go on to the most important one. James McGreevy. He the one who signed off on what we call the Civil Rights Act, y'all. This guy right here, James McGreevy. 2004, he passed it.
He was
Oh, I missed him.
he was what you call it when you lose your position. He had a lot of scandal where they found out that he was a
Censored?
no, McGreevy.
Yeah. Censor
He
or
was a homosexual. He lives in Plainfield where we used to live.
I wouldn't doubt it.
But he had a lot of scandals going on with him.
I wouldn't doubt it. Okay, so everybody see this guy, Richard J. Hughes? He's the 45th governor of New Jersey. This guy right here. He was the 45th. Then you got Robert Maynard, because this guy was just acting. The 44th and the 43rd is Alfred Driscoll. And Alfred Driscoll appointed Arthur T. Vanderbilt, the first Chief Justice of the Administrative Government under the Judiciary Act at that particular time. Now, why is this important? Alfred Driscoll, everybody see him? 43rd governor, Arthur T. Vanderbilt. Okay, let's be here. This is the Chief Justice who appointed him. He was appointed by Alfred Driscoll. Read real quick. Career, Countess Middleton.
Many of Vanderbilt's ideas for court reform had been incorporated into the new judicial article of the New Jersey Constitution. One of those innovations was the designation of the Chief Justice as the administrative head of all courts in the state, replacing the previous system of almost completely autonomous courts. As Chief Justice, he created the first state administrative office of the courts in the nation.
Do y'all hear that? It said the nation. Why has no one told us this? Why has no one did this homework? I'm gonna show you, this is homework I'm doing for y'all. I care about y'all salvation. Continue to read.
An appreciation of the changes brought to the New Jersey judicial system can be gained from a comparison between the structure of the courts before the new Constitution and after. There were over 20 different courts in the system, such as Superior Court, Supreme Court, Court of Errors and Appeals, Chancery, Oyer and Terminer, Orphans Court, County Court, General Sessions, Quarter Sessions, etc., which were replaced by the New Jersey Supreme Court, the Superior Court, Law, Chancery, and Appellate Divisions, County Court, County District Court, and the Juvenile and Domestic Relations Court. The county courts were merged into the Superior Court, Law Division, as were the county district courts, now known as the Special Civil Part of the Superior Court, and the Juvenile and Domestic Relations Court, now the family part of the Chancery Division. These were joined by the tax court. In addition, there are,
That's right. Did you read this right here?
right. In addition,
Okay.
there are municipal
fine.
courts which
That's
handled.
That's fine. Okay,
Okay.
so as you can see, under this Chief Justice, prior to him, the new administration, you see that the King's Courts was there. Superior Court, Supreme Court, Court of Errors and Appeals, Chancery, Oyer Terminus, Orphan Court, County Court, General Session, Quarter Session, etc. Those are courts of the King's Bench. Did y'all hear me?
Yes.
If you don't believe me, let's make sure. The King's Bench. Thank you, Queen. The courts of the King's Bench. Read that, Countess Middleton.
The courts of the King's Bench, formerly known as the Court of the King before the King himself, was a court of common law in the English legal system. Created in the late 12th to early 13th century from the Curia Regis, the King's Bench initially followed the monarch on his travels. The King's Bench finally joined the Court of Common Pleas and Exchequer of Pleas in Westminster Hall in 318, making its last travels in 1421. The King's Bench was merged into the High Court of Justice by the Supreme Court of Judicature Act 1873, after which point the King's Bench was a division within the High Court. The King's Bench was staffed by one Chief Justice, now the Lord Chief Justice of England and Wales, and usually 3 Husney justices. In the 15th and 16th centuries, the King's Bench jurisdiction and caseload was significantly challenged by the rise of the Court of Chancery and equitable doctrines as one of the 2 principal common law courts, along with the Common Pleas. To recover, the King's Bench undertook a scheme of revolutionary reform, creating less expensive, faster, and more versatile types of pleading in the form of bills, as opposed to the more traditional writs. Although not immediately stemming the tide, it helped the King's Bench to recover and increase its workload in the long term.
Okay, stop right there. So we see the King's Bench are nothing more than authority that the king has based off his council. His council rules the King's Bench, and different circuits were created on the King's Bench to deal with different situations. Courts of orders and terms were courts that deal with treason, felonies, etc. Courts of Common Pleas deal with issues that involve subjects against themselves. Courts of Exchequer was a court deal with fines owed to the king, etc. So our courts, i.e. the King's courts, were established to deal with the subjects of the land based off the use of the land. Everybody follow?
Follow.
Okay. New Jersey revised New Jersey's Constitution, their website. Everybody see it?
Yes.
Read that first statement.
1947 State Constitution. New Jersey's current state constitution was drafted by a convention of delegates from each county, convened from 12th of June to the 10th of September, 1947. The new charter further strengthened the office of the governor and reorganized and unified the judicial system under the Supreme Court. The document also included new rights and protections and required the legislature to provide for a thorough and efficient system of free public schools.
Okay, all right. So the governor under the 1947 Constitution had the ability to be able to create a new administrative government based off legislation that were passed contrary to the original legislation as prescribed by the previous constitutions. Because you have a difference between what we call government, an individual, and a business. I say it again. You got a difference between an individual, a government, and a business. A government is not a business, and a business is not a government. A government is composed of individuals who deal with the affairs of the government, not relating to business as defined by the term business. And we know business deals with what? Commerce, working, labor, finances, right? Government deals with office, tenure, what else? It deals with prescribed duties with the affairs of the citizens. That's what the government is. It's known as the polity. The polity is composed of the people who come together and create a quorum to deal with the affairs of the whole. That makes sense to everybody. That makes sense?
Crystal clear.
Yes.
Okay. We know that the original obligation of the Constitution is for what? Checks and balances. It's the vesting power and lieu of the distribution of the powers of the government. And the government is just those people sitting in that court, right? Just like we sitting here. We're sitting in a courtroom, and we got the powers of the government, which we say that we come from. That has always been here. But the only way we can establish that is based off the meeting of the mind. Based off the contract that authorizes 61-28, right, sit under the charters of Great Britain, saved from repeal, an act to incorporate trustees of religious society for property held in corporation in place thereof. Because all the property, i.e. estates, which contains all the assets, are being held by those who are sitting in a position they don't belong, i.e. corporations. That are businesses that are not the individuals that denote to the government that created the trust in the first place on behalf of the grantor. So now what comes into play? The legislation is not the problem. It's the execution of the legislation and the upholding of what's being executed as qualified by the legislation. Because legislation means law that's legislated. The question becomes, who creates the law that's legislated? Is it the grantees or the grantor? Because the law that they legislate governs their ability to be able to use the land. And their government is based off land use. It ain't based off ownership. Do everybody understand that? Because the only one who owns it is the grantor. It's a limited clause. It's automatically put in place. The grantor is not going to give up his possession without what we call good faith. You give me something equal, and what else could be equal to land? Nothing. Can everybody, what can you give me in place of land?
No.
Nothing.
Everything
All right.
come from the land.
All right. So we know without the legislation, you got no legs to stand on. The executive represents the hand, the ability to execute what was legislated, the authority, the contract, the commission, the tenure, the holding, the letter pack. And that's upheld by who? The judicial system. Everybody understand?
Follow.
Follow.
Now we talking about a 1947 Constitution that comes to the time of what we call Arthur T. Vanderbilt, which was appointed by the 43rd governor, Alfred Driscoll. Now let's go here for a second.
Alfred Driscoll.
Yeah, that's not it. I'm looking for. Let's see. Let's go here. I don't think I opened it up. Wait 1 second. Did it open up? Here we go. Can everybody see this?
Yeah.
Yes.
Okay. Continue to read, Countess Middleton.
Chief Justice Richard J. Hughes, architect of a responsive administrative process. The administrative process is a governmental tool. It is no more conservative or liberal than the automobile that carries the bureaucrat to his work. It can be used to go right, left, or down the center of the road. It can be used both as an instrument of law reform and as a protection against law reform. Author of landmark opinions designed to ensure and protect fundamental rights in other vital areas, Chief Justice Hughes has clearly earned distinction as architect and effective advocate of a responsive administrative process, one which vigilantly seeks to assure fair treatment to the individual while fostering enlightened understanding and cooperation between the individual and state government. His has been a truly compassionate approach to law reform.
Stop. Now you heard what he said, law reform. Now they said law reform can be used it's used both as an instrument of law reform and as a protection against law reform.
Yeah.
So what use is he using? Is it for the protection or for an instrument of law reform or protection against law reform? Because the law reform means to what? Make law better. Reform means to make better or make it closer to the original. Reformation. That's what it means. That's what it means. Okay? All right, continue on.
Okay. Following adoption of the 1947 state constitution, then Governor Alfred E. Driscoll, in his annual message to the legislature in January 1948, urged enactment of legislation to make the procedure of our administrative agencies conform to accepted standards of fair and uniform administration according to the rule of law. The governor's drive to achieve a forward-looking state administrative procedure act enlisted support from many individuals and groups. Among those in the forefront were Arthur T. Vanderbilt, then Chief Justice Designate, Nathan L. Jacobs, later Associate Justice of the Supreme Court, Milton B. Conford, later Presiding Judge for Administration of the Appellate Division of the Superior Court, and Alfred C. Clapp, then State Senator from Essex County, editor of the New Jersey Law Journal, and later Presiding Judge of the Appellate Division. Despite vigorous efforts on its behalf, however, the proposed beneficial and much needed legislation fell short of adoption. In this respect, the modernization of our state government provided by the new state constitution and the innovations flowing from it remained incomplete. While further attempts to secure passage of an Administrative Procedure Act were made in succeeding legislative sessions, it was not until 1968, during the administration of then Governor Richard J. Hughes, that a model act was brought to fruition. In that year, the legislature adopted Senate number 667, designed to regulate practice and procedure of state administrative agencies.
Stop right there. Okay. Now let's just look at what a little verbiage and what the administration entails. Read that right there.
The Administrative Procedure Act is a strongly marked, long sought, and widely heralded advance in democratic government. It embarks upon a new field of legislation of broad application in the administrative, quote unquote, area of government, lying between the traditional legislative and fundamental judicial processes on one hand, and authorized executive functions on the other.
Did you hear that? So it said it's not the traditional legislation, but a new legislation on one hand and executive functions on the other. Contrary, a new Administrative Procedure Act is a new legislation different from the traditional on one hand and the executive functions on the other. So you have changed totally. Go ahead.
Yes. Although it is brief, it is a comprehensive charter of private liberty and a solemn undertaking of official fairness. It is intended as a guide to him who seeks fair play and equal rights under law, as well as to those invested with executive authority. It upholds law and yet lightens the burden on those on whom the law may impinge. It enunciates and emphasizes the tripartite form of our democracy and brings into relief the ever essential declaration that this is a government of law rather than of men.
Now that's a lot. You just said it upholds the law and yet lightens the burden of those on whom the law may impinge. Everybody is impinged by the law. So if you can lighten the impinges of the law which you infringed upon, that means that makes you judge and jury. Yeah. Why do you think the governor and the president have the authority to grant pardons, treason, etc.? Because that's the power they control, that they will, under the new Administration Act created by all these what we call Chief Justices. And all these Chief Justices from Richard J. Hughes going all the way back to Alfred Driscoll. Where's he at? Right here. Alfred Driscoll were all fraudulent. Even the Chief Justice were fraudulent. How I know that? Let's look how they understood that parties may change, but the positions don't. You have to be who you truly say you are, because if you don't, you're gonna get in trouble, you're gonna get penalized. All right, let's see. William Franklin. Read this first paragraph, Council Middleton.
William Franklin was an American-born attorney, soldier. William Franklin was an American-born attorney, soldier, politician, and colonial administrator. He was the acknowledged illegitimate son of Benjamin Franklin. William Franklin was the last colonial governor of New Jersey, 1763 to 1776, and a steadfast loyalist throughout the American Revolutionary War. In contrast, his father Benjamin was in later life one of the most prominent of the patriot leaders of the American Revolution and a founding father of the United States. Following imprisonment by patriots in 1776 to 1778, William became the chief leader of the Loyalists. From his base in New York City, he organized military units to fight on the British side. In 1782, he went into exile in Britain. He lived in London until his death.
Okay, now look at where he lived at. The Proprietary House. This is still vacant. It's under the historical archives.
It's a museum now.
It's a museum now. It's about to be our office. Why do I say that? Because the last world governor was William Franklin. William Franklin paroled against the Continental Congress by way of them locking them up, because his obligation was to the crown, not to the administration as established by the founding fathers when they broke away and declared their independence by way of the founding fathers, which we can see the second governor, William Patterson, was one of them. Can we agree? Everybody follow the paper trail?
Agree.
Yes.
Follow.
All right, let's get a little further. Now, what makes this funny is that Alfred Driscoll, the 45th governor, signed the 1947 Constitution in gymnasium of Rutgers University. That's where he signed. Let's prove it. Everybody see this?
Yes.
This is John Hancock, Alfred Eastlack Driscoll, governor of New Jersey. The charter was signed in Rutgers University in their gymnasium. Rutgers University symbol is what? A knight, right? Called Rutgers Knights. That goes back to the history of the English Parliament of Simon de Montfort. Simon de Montfort was a rebel baron. He was called a Knights of the Shire. A Knights of the Shire is the counterpart to what we call the burghers. Let's just go there for a second.
Scarlet Knights.
Scarlet Knights. They're called the Scarlet Knights. Now, they met in Rutgers University and created a charter in Rutgers University after they locked up William Franklin, the last world governor of the colonies, because they became colonies, then they became states on September 20th. All right? They declared themselves an administrative government under the 1947 Constitution by way of the 43rd Governor Alfred Driscoll by appointing Arthur T. Vanderbilt. And they declared themselves a new administrative government, but yet did it on chartered territory because Rutgers University was chartered by who? William Franklin. It's a royal charter. All right, read the first part, Countess Middleton.
Yes. Simon de Montfort, 6th Earl of Leicester, later sometimes referred to as Simon V de Montfort to distinguish him from his namesake relatives, was a nobleman of French origin and a member of the English peerage, who led the baronial opposition to the rule of King Henry III of England, culminating in the Second Barons' War. Following his initial victories over royal forces, he became de facto ruler of the country and played a major role in the constitution development of England.
Stop. Okay. Simon de Montfort was a royal baron. Let's look at it, see if it gives us that. Let's see a second. Okay, he was a knight of the Shire. So he was a royal baron. He was married to Eleanor of Leicestershire. Everybody see that? Eleanor of England, of Leicestershire.
Okay.
Just click her. Everybody see Leicester. Everybody see that?
Yes.
Leicestershire.
Leicestershire. Her father was John, who signed the Magna Carta. Everybody see that?
Yes.
Yes.
Okay. Simon de Montfort, who was married to Eleanor of Leicestershire, father was John, and John's son was Henry III. Which is this guy. Everybody follow?
Follow.
John, the father of Henry III, was the son of Henry II, the son of Godfrey, the 5th Count of Anjou, where I descended down from, based on what we call English peerage. English peerage is granted by a title of nobility. Everybody follow?
Follow.
Okay. Let's move forward for the sake of time. Okay. Now, these barons were called Knights of the Shire. The Knights of the Shire is nothing more than peoples in the communities commissioned for an office. Nothing more than what we call the House of Burghers. The House of Burghers was nothing but a title for free men of the county. Counties were called in our days hundreds or wapentake. They go back to the time of the Plantagenet crown. Counties are called shires. Shires are called wapentake. They have many names, but we have to use based off the meaning of the mind of the original contract when they were created. So we have to have the mind of our ancestors, because if we don't have the mind of our ancestors, we can't connect it from that mind of the past to the minds of today, because the position is still there. The parties change, but the position is still there. They have waived that position, and I'm gonna show you why. Everybody ready for this?
Ready,
Yes.
King.
I hope y'all are. Ward versus King. I thought I said that. Okay, yes, I did. I thought I said that. There we go. All right. Everybody see this?
Yeah, King.
Yes.
See this case? Who it says here? Who is this person right here?
Chief Judge Vanderbilt.
Chief Justice Vanderbilt.
The
Clipper.
same Chief Justice,
That was appointed by Driscoll after the
47 Constitution, who rechanged the courts of New Jersey. Prior to him, the courts of the King's Bench were there. Everybody follow?
Follow.
Follow.
Now, I said positions don't, parties may change, but positions don't. Let me get background of this case. This case was filed, read this, Archbishop.
The opinion of the court was delivered by Chief Justice Vanderbilt. It says, the plaintiff, a police officer of the city of Newark since 1924, applied for and was granted a leave of absence without pay for a period of February 1st, 1949 to May 31st, 1949, to enable him to become a candidate in the city commission election in Newark on May 10th. In the course of the campaign and while on leave of absence, he distributed literature and made several speeches and radio addresses, and a number of which he asserted both generally and specifically that there was corruption, graft and misconduct in the police department of the city of Newark, and charged his superiors with knowledge of participation therein. In the middle of the campaign and while the plaintiff was still on leave, the chief of police called him in and requested him to furnish details with respect to the charges he had been making, but the plaintiff refused to answer any questions. His leave of absence was not revoked, however, and he was permitted to continue with his campaigning.
Stop. Okay. So a police officer employed as a police officer in the city of Newark. He went on leave to undertake some private citizen activity in regards to exposing some corruption that was done as an employee, being employed by the employee, which happens to be Newark Police Department. He was forced as an administrative officer to give up the information in regards to the so-called corruption that he said to have found out. But he pleaded the fifth because he knew that the corruption went all the way up. Everybody follow?
Oh, okay.
Continue.
On June 1st.
Archbishop, now I'm giving you a
I'm
rep.
sorry.
Okay.
Okay.
On June 1st, the first day of his return to active duty, the plaintiff was served with departmental charges preferred by the chief of police and was suspended from duty without pay pending the hearing of those charges. The charges, all of which are founded upon the violation of departmental rules and regulations, are 6 in number. 1, willful disobedience of orders and failure to report crime to his commanding officer based upon his refusal to answer the questions put to him by his chief. 2, neglect of duty and failure to report the commission of crime based upon a radio address made on April 4th, where he professed to know the names of certain violators of the law. 3, failure to take proper police action and to divulge information to his superior officers based upon a broadcast made on April 11th to the effect that narcotic peddlers were operating in Newark. 4, failure to take proper police action and to divulge information to his superior officers based upon a statement made in the same broadcast in which he publicly named a number of alleged gamblers still at large. Conduct contrary to good order and discipline in the making of false and inaccurate statements and broadcasts made on April 18th and May 9th concerning the handling by the police department of the case of a person arrested for carrying concealed weapons. And 6, public disparagement and unfavorable comment on the official actions of the Director of Public Safety, whom he charged in the course of a broadcast on May 9th with neglecting his public duties. Prior to the date set for the hearing of these departmental charges by Director of Public Safety Keenan, the plaintiff commenced the present proceeding in lieu of prerogative writ, and on June 27, 1949, on his motion, a summary judgment was entered in his favor, vacating his suspension, directing his reinstatement, and ordering that the charges against him be expunged, that the defendant Director of Public Safety be permanently enjoined from conducting any hearings on these charges, and that the Board of Commissioners reimburse him for the loss of his salary between the date of his suspension and his reinstatement. From this judgment, the defendants took an appeal to the appellate division of the Superior Court. That appeal has now been brought here on our own certification.
Okay. So at this time, the king prerogative was there. This particular employee thought upon himself to act in his private capacity as a citizen to expose corruption on all levels, dealing with the agency created by the state. And the officers of the state took it upon themselves to file an appeal because the trial court, based off the law, gave him remedy. But then the defendant sought relief in the appellate court based off the Administrative Procedure Act, because this chief judge was the first judge under the Administrative Procedure Act. Do we follow?
Follow, okay.
The Supreme Court is a trial court. I mean, an appellate court. Before it became Supreme Court, it became what it was called the Courts of Errors and the Courts of Appeal. So the person was an appellant to the new Supreme Court of 1947 that was established by Arthur T. Vanderbilt, by him being commissioned by Alfred Driscoll. He was going based off the administration that preceded it, which was under the king's bench, but wasn't no king there. Now the court did what they were supposed to, but then the defendants appealed it, and the Supreme Court under Arthur T. Vanderbilt overturned his decision. There's a decision. He told that police officer, "You work for us. You're a citizen just like everybody else under this new administration. Yeah, a prerogative writ can be given, but it won't be done by you. Because if we allowed you to do it, then you'll be telling on everybody else." Does that make sense to everybody?
Crystal.
Follow.
Let's read it for ourselves. Doctrine, go ahead and read it. Archbishop.
The doctrine that a litigant must exhaust his administrative remedies before he may resort to the courts dates back to the advent of the Interstate Commerce Commission in 1887. Berger, Exhaustion of Administrative Remedies, 1939, Yale. And the inception of the modern phase of administrative law marked by the creation of commissions with commingled legislative, executive, and judicial powers, as distinguished from the traditional body of administrative law, by which officials and bodies in the executive branch of government, both at the local and higher levels, were kept within their respective spheres and were held to the methods prescribed by law by a series of remedies in the courts, ranging from the prerogative writs and bills in equity for injunction to suits at law for damages. intended as a simple rule of orderly procedure designed to provide uniformly that administrative bodies might perform their statutory functions without preliminary litigation in the courts.
Stop.
United States
Okay.
versus-
Now we're hearing that this Chief Justice, who appointed by the 43rd governor, is that clearly stated that the remedy for this administrative abuse is through a prerogative writ. Can you just say that?
Yep.
Right there. Now, mind you, it says to check the powers that were created under this new traditional administrative law. Read this part right here, Archbishop. 1 second. Start from right here. Hold on. In the section right here. Everybody listen to what he reads. Go ahead.
All right. Which part? Oh,
Right here, in the exception.
Oh, and the inception of the modern phase of administrative law, marked by the creation of commissions with commingled legislative, executive, and judicial powers as distinguished from the traditional body administrative law, by which officials and bodies in the executive branch of government, both at the local and higher levels, were kept within their respective spheres and were held to the methods prescribed by law by a series of remedies in the courts, ranging from the prerogative writs and bills in equity for injunction to suits at law for damages.
Stop. Okay. Now I'm suing the state, right? Because of what they're doing under the administrative law, and they're forcing us to exhaust our remedy under administrative procedures, which we just clearly proved by the Chief Justice had to deal with interstate commerce. Didn't he say that?
Yep.
He just said it based off the commingled legislative and executive judicial power as distinguished from the traditional body of administrative law. And this was done by way of the executive branch, both at the local and higher level, where they should be kept within their respective spheres. And the only way you can do that is by a prescribed by law is through a prerogative writ. Now, how we know that? Because when we just go back to here, where is it at? Where's that? Right here. Now, then we just read, the Administrative Procedure Act is strongly marked, long sought, and widely heralded advance in democratic government. This is from Alfred Driscoll all the way up to Richard G. Hughes, the one who created the Administrative Procedure Act on my birthday, January 14th, 1969, a year before I was born. And he said exactly what Administrative Judge, Chief Justice Arthur T. Vanderbilt said at the time of the creation of the Administrative Procedure Act by way of the Administrative Constitution of 1947. And he said the Administrative Procedure Act, i.e. the Constitution of 1947, is a strongly marked, long sought, and widely heralded advance in democratic government. It embarked upon a new field of legislation, a broad application, and administrative area of government lying between the judicial legislation and fundamental judicial process on one hand and authorized executive function on the other. That's the same thing we just read in this case. Where we get that? Let me go back to it. Oh, right here. The inception of modern phases of administrative law marked by the creation of commission with communal legislative, executive, and judicial power as distinguished from traditional body administrative law by which officials and bodies in their executive branch of government, both at the local and higher level, were kept within their respective spheres and were held to the method as prescribed by law by a series of remedies in the court ranging from prerogative writs. So the only way to hold any court in bound is by way of a prerogative writ. This was the first Chief Justice said. Now the cop tried to do it, and what did the Chief Justice say? He said he can't do it. Let's just go to the dissent right here. Keep reading.
Intended.
Right here, enough.
Okay. Enough has been said to raise grave doubts as to wisdom of adopting the rule of exhaustion of administrative remedies as contended for by the defendants. To determine what rule of law should be adopted in the case before us, we must consider what was intended to be accomplished by Article 6, Section 5, Paragraph 4 of our Constitution. 4. Prerogative writs are superseded and in lieu thereof.
I'm sorry.
In lieu thereof, review, hearing, and relief shall be afforded in a superior court on terms and in the manner provided by rules of the Supreme Court as of right, except in criminal causes, which such review should be discretionary.
Stop. So this is the Chief Justice of the 1947 Constitution of a new administrative government that's not the same as the one that existed before he got commissioned by Alfred Driscoll. And we just read by Alfred Driscoll and all the governors after him, they were all down with the Administrative Procedure Act, which was unchecked. But Arthur T. Vanderbilt said you were supposed to be checked. Everybody see that?
Say it again.
Follow.
Does that make sense to everybody?
It's Crystal.
Follow.
I'm gonna say it again. We are now, all the constitutions of all the states of the United States go back to this Constitution of 1947. Because none of their constitution invoked the power of the prerogative writ. United States Supreme Court can't do it, and Marbury versus Madison says it. The Supreme Court in New Jersey said they can't do it, because I got the proof that said they can't do it. It said it right here. They've been superseded. Supersede means what? Replace. Continue to read.
The prerogative writs were superseded in the 1947 Constitution because certain phases of their procedure had been the cause of widespread dissatisfaction. First, there was always the danger of discovering in an appellate court that one had sued out the wrong prerogative writ, rendering it necessary to start over again. If indeed one had not lost his cause of action by laches or through an intervening change of position. Thus, for example, one might have applied for and been granted certiorari only to discover that argument and determination that he should have proceeded by way of quotanto or mandamus or vice versa.
Okay, all these are prerogatives of the crown. Everybody was using it, but you can't use it because the origin of the meeting of the minds of the prerogative goes back to the king. And it loses its power if it's not done based off the origin. Remember, parties may change, but positions don't. And for parties exercising power based off the position that they don't supposed to be in, then the power can be used for falsehood. And that's what's going on right now. Everybody understand?
Yes.
Follow.
Okay, continue to read. Let me just go down a little further. Start here.
Says term of the Supreme Court and the next ensuing term of the Court of Heirs and Appeals, there was always a lapse of at least one term and generally more than one term before any appeal could ultimately be heard in the court of the last resort. To be considered in dealing with the constitutional provisions for proceeding in lieu of prerogative writs is the policy of the new Constitution against delay and delaying tactics in all litigation. Construction of the Constitution, Article 6, Section 2, Paragraph 3, conferring on the Supreme Court the power to make rules governing the administration of all courts in the state and subject to law the practice and procedure in all such courts. And Article 6, Section 7, Paragraph 1 and 2, designating the Chief Justice of the Supreme Court as the administrative head of all of the courts in the state and giving him the power to assign judges of the Superior Court to the divisions and parts of the Superior Court, and from time to time to transfer judges from one assignment to another as need appears. The importance of dispatch in this particular class of cases is recognized in the rule above referred to, especially in Rule 3:81-6, advancing such proceedings for hearing, trial, and disposition by the court, and in Rule 3:81-4, providing for motions for summary judgment on proceedings in lieu of prerogative writs brought to enforce a ministerial act or duty.
Okay, so here's Chief Justice Arthur T. Vanderbilt telling you the power of the prerogative writ. Let's see what else you got to say about Read this.
Policy of enlarging the record by extrinsic evidence made it possible to extend the scope of the writ beyond the review of the judicial action of inferior courts to include quasi-judicial, quasi-legislative, and administrative action of all kinds, even including cases where there was an abuse of administrative discretion to do justice between the private citizen and the public official or body in many types of cases where it could have not been attained under the common law rule to the contrary.
Read that again.
It says the policy of enlarging the record by extrinsic evidence made it possible to extend the scope of the writ beyond the review of the judicial action of inferior courts to include quasi-judicial, quasi-legislative, and administrative action of all kinds, even including cases where there was an abuse of administrative discretion, to do justice between the private citizen and the public official or body in many types of cases where it could not have been attained under the common law rule to the contrary. The variety of uses to which certiorari was put in civil matters, its use in criminal causes is dealt with separately in the new Constitution and is not treated here, was summarized by Chief Justice Green in Treasurer of Camden versus Mulford.
Okay, continue to read.
In this state, the remedy certiorari has been extended to wrongs inflicted upon individuals, whether by judicial decision, by corporate acts, or by the acts of special jurisdictions created by statute. Thus, it is habitually used as a remedy against unlawful taxation, either for state, county, township, or city purposes. And while the remedy has been denied in other states as dangerous or prejudicial to the public welfare, no such evil has been experienced from the use of the remedy, while it has been found eminently salutary and efficacious as a protection to private rights against oppressive and illegal taxation. It is used to test the legality of an election, State versus Justice of Middlesex, State versus Anderson, to test the validity of a bylaw of a municipal corporation, State versus Corporation of New Brunswick, to test the validity of the classing and assessing of the militia order, the Militia Act of 1794, State versus Chambers, review the return list of delinquents and executions issued for the collection of fines imposed for neglect of militia duty, State versus Kirby, State versus Atkinson, the laying out of a road under an act incorporating the Turnpike Company, State versus Newark and Pompton Turnpike Company, the appointment and the proceedings of commissioners appointed to value lands taken by corporations for their use, and to appraise damages by special statutory authority, the State versus the Morris Canal, Bennett versus Railroad, Van Winkle versus Railroad, and Smith versus the Trenton Delaware Falls Company. The special significance of the broad scope of certiorari in New Jersey in protecting an aggrieved citizen from almost every form of improper official action is epitomized by Holdsworth in speaking of the prerogative writs generally. This judicial control could be applied at the suit of the private citizen. The private citizen could set in motion the different forms of procedure open to the Crown, and in addition, he could bring a civil action. This power to bring a civil action was an effective control, a safeguard of the liberty of the subject, and one of the best of all securities for the maintenance of the supremacy of the law.
Did y'all hear that? Did y'all hear that? That's the first Chief Justice of the administration of the government that superseded every administration of any state's government of the United States. And he said none of those administrations, including this administration of 1947, has the authority than the private citizen to invoke the procedures of the crown. He said it. And we know the crown is in the corporation soul, and the corporation soul represents the king. Why? Because king is head of the king's bench, and the prerogative is the prerogative of a king. Everybody understand?
Wow.
Follow.
Now, this Chief Justice said that. Let's listen to another Chief Justice of the Supreme Court. Welling versus Harris. This is another one appointed by Alfred Driscoll. No, this was Chief Justice Vincent Brianda. He was appointed by the 44th governor, Robert Maynard. Watch what he says. All right, you can read it again. Go ahead, Countess Middleton.
This case is a civil action begun by complaint in the usual course for judicial review of a final decision of the Secretary of the Department of Health, Education, and Welfare, denying application for benefits claimed under the Social Security Act, Title 42, USC. The jurisdiction of the court arises from Statute 42, USC 405. The provisions of the statutes taken together with the accumulated decisional law make the action essentially the same in nature and scope as the common law writ of certiorari, a prerogative writ. The action, as well as the rule of decision, is closely analogous to those governing that prerogative writ. The evidence consists of the record of proceedings before the administrative agency. The rule of decision on review of that record is whether it contains substantial evidence to support the agency decision in most cases. In some cases, the review may include the question whether the agency decision correctly applied governing law, including rules and regulations, and in others may bring into question the meaning and interpretation of that law, or its validity, or the constitutionality of one provision or another, or of the procedures employed. Since the federal courts are not courts of general jurisdiction, possessing all the powers of the King's Bench, the accumulation of precedent in the general field is somewhat nebulous, especially since the law in each of the circuits is controlled by the decisions of the Court of Appeals in the particular circuit, until such time as a decision of the Supreme Court of the United States resolves differences between the circuits.
Stop. Now they still haven't resolved that issue because the Supreme Court doesn't have the power of the prerogative bits of the King's Bench. How I know that? Read on.
1280, the state of, number 1280, the state of New Jersey, whose boundaries coincide with those of this district, is one of the original 13 states of the Union and is a common law state. The structure of its law may be looked to for general background about prerogative writs in general and the writ of certiorari in particular. New Jersey's first constitution, adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as a state. Article 22 of that constitution continued the common law of England in force. That constitution was replaced by the Constitution of 1844, modeled largely in structure and content on the Constitution of the United States.
Did y'all hear that? Did y'all hear that?
Mhm.
United States ain't got nothing on New Jersey. Your Constitution came from the Constitution of New Jersey by way of the founding fathers, William Patterson, who helped draft the Constitution for y'all. Go ahead, continue.
Okay. By Article 10, Paragraph 1, it too continued in force the common law, as well as the existing courts of law and equity. So also the current Constitution of 1947 by Article 11, Section 1, Paragraph 3, continued in force all existing law. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's Bench, which the legislature was powerless to cut down or to assign to other courts. This principle was especially strong in the field of prerogative writs, of which certiorari was the most frequently sought. See, for example, City of East Orange versus Hussey, and Flanagan versus Plainfield. The complexities and technicalities involving the prerogative writs, including certiorari, induced the draftsmen of the 1947 Constitution to erase the procedural niceties while preserving the judicial authority and the remedies. This was achieved by a single sentence. Prerogative writs are superseded, and in lieu thereof, review, hearing, and relief shall be afforded in the Supreme Court on terms and in the manner provided by the rules of the Supreme Court, as of right, except in criminal causes where review shall be discretionary. New Jersey Constitution, 1947, Article 6, Section 5, Paragraph 4. Thus, in New Jersey, where prerogative writ jurisdiction is constitutionally placed in the Superior Court, judicial review of administrative action is afforded as of right, and no statute is needed to provide that review.
Okay, so a prerogative writ under the Supreme Court says it's a matter of right, but it's only be made by a private citizen. A private citizen that goes back to the authority that the procedure of the Crown can enforce. So you can't be a private citizen and enforce the prerogative of the Crown, as Chief Justice Arthur Vanderbilt said, as a police officer, because you work for us. All right, everybody understand?
Crystal.
All right,
Clear.
let's go ahead.
Clear.
Let's see. Let's go here. Let's see another court case. This is Borovitz versus Barber. This is Judge Henher. He was also appointed by Alfred Driscoll. Let me just go there, list of justices. Let me just show you his name. Right here, Harry Herring. Everybody see that?
See it.
Yes.
Okay, that's another. He was appointed by Alfred Driscoll as well. All right, let's go back to where he was. Start here, Council Middleton.
Okay. Judge Hare, there can be no doubt that the former Court of Chancery had jurisdiction of the care and custody of illegitimates.
Hold on, I'm sorry. Go a little further. Yeah, right here. You see that?
Okay. The 1947 Constitution, Article 6, Section 3, Paragraph 2 provides, the Superior Court shall have original general jurisdiction throughout the state in all causes. And upon that authority, appellant seems to argue that every imaginable litigation, whatever its nature, however slight its importance and regardless of its historical background, may be initiated in the Superior Court. If this reasoning be sound, then not only bastardy cases, but violations of the Disorderly Persons Act, infractions against municipal ordinances, all of the daily grind of the magistrates' courts become eligible for institution in the Superior Court. And no matter of rule can stem the flow because the authority lies in the Constitution and is untrammeled. The Superior Court is not geared to such a practice and would not be able physically to assume it without a radical overturn in rules, manpower, and court facilities. Because if original jurisdiction is to be assumed in all cases, then it seems equipment for assuming jurisdiction must be supplied, local courtrooms, judges, courts, dockets, practically a duplication, if not an absorption of the entire inferior court system. The possibility of such a contingency brings a sense of shock followed by deep concern. And we believe that those sensations would be quickly shared by the bar, the bench, litigants, and the tax-paying public if the suggested practice were imminent and the present inferior courts were to be paralleled by a superior court system. It is true that literally the words of the Constitution are capable of such a meaning, but we believe that the application of familiar rules leads directly away from that construction.
Okay, give me 1 second. Let me find it. Okay, right here. Start right here.
Plaintiff has the custody and no one disputes her right to it. Oh, okay. Since this is not a proceeding in strict bastardy, we have passed over the facts that neither the mother nor her child has any settlement in this state and is not shown to be likely to become public charges here, and that no local authority burdened with the care of the poor is made a party.
Stop. Okay, these are the case we just read previously, as well as this case, all deal with the question of administrations who's supposed to be overseeing the social welfare and the social security of the inhabitants. Everybody follow?
Follow.
They're not doing that because the land use regulation for the administration is looking out for somebody else other than the subjects who are subject to a different administration prior to their undertaking. Everybody follow?
Follow.
Okay, and as a result of that, we have no protection in regards to the social security and our social welfare because the administration is not created for that purpose. That's the reason why we have to create our own based off what already existed, based off the original contract. But the only way we can prove that is by way of meetings of the minds. Because their meeting of the minds is how we got in this position. But our meeting of the mind predate theirs. Why? Because the contract. So the only way we can question that contract is by a prerogative writ. A regular circulator, make the record claim, make the record, a written circulator means make clean the record. And that can only be done by another prerogative writ, manuments or call warranto. Show just cause how you got the authority to do what you're doing. But the complaint can be made by a citizen of their administration. It must be made by a private citizen. And the best private citizen is the king himself. Because the prerogative is the king's prerogative and not a private individual. Because if that was the case, that police officer could have did it himself. The court ruled in his favor, but when it was reviewed by the Supreme Court said, no, you can't do that. You be telling on everybody else. Continue to read.
Before discussing the effect of the express words of the Constitution, we shall explore the possibility of an original jurisdiction in the Superior Court acquired from a superseded court to whose powers it is the successor. The only court through whose powers such an inherited jurisdiction could come would be the former Supreme Court. Article 22 of the 1776 Constitution provided, the common law of England, as well as so much of the statute law, as have been heretofore practiced in this colony, shall remain in force until they shall be altered by a future law of the legislature. Article 21 of the same document provided that all the laws of this province contained in the edition lately published by Mr. Allinson shall be and remain in full force until altered by the legislature of this colony. That Constitution also, by inference rather than by direct statement, provided for the continuance of the Supreme Court, and the legislature, 3 months later, October 2nd, 1776, enacted that the several courts of law and equity of this state shall be confirmed and established, and continue to be held with like powers under the present government, as they were held at and before the Declaration of Independency, lately made by the Honorable, the Continental Congress. It has been held that by the conjunction of the ordinance of Lord Cornbury, enacted in 1704, other ordinances, including the ordinance of 1714, passed by Governor Hunter and his council, the 1776 Constitution, the Statute Supra of October 2nd, 1776, and the Constitution of 1844, the former Supreme Court became vested with the ordinary common law original jurisdiction of the Court of King's Bench, shared to some extent by the county circuit courts and the courts of common pleas, and that it became more exclusively vested with the appellate and extraordinary 400 jurisdiction of that English court.
Okay, let's go down here. Right here.
There can be no doubt that the former Court of Chancery had jurisdiction of the care and custody of illegitimates, and that this jurisdiction now rests in the Superior Court under the Constitution of 1947. This has been a function of Chancery from the earliest time. The general jurisdiction of Chancery over the persons and estates of infants for the protection of both is supposed to have originated in the prerogative of the Crown, arising from its general duty as parents patriae to protect persons who have no other rightful protector, but partaking, says Story, as the prerogative does, more of the nature of a judicial administration of rights and duties in foro conscientiae than of a strict executive authority. It was very naturally exercised by the Court of Chancery as a branch of its original general jurisdiction. Accordingly, he adds, the doctrine now commonly maintained is that the general superintendence and protective jurisdiction of the Court of Chancery over the persons and property of infants is a delegation of the rights and duty of the Crown, that it belonged to the court and was exercised by it from its first establishment, and that this general jurisdiction was not even suspended by the statute 411 of Henry VIII, erecting the Court of Wards and Liveries. The jurisdiction possessed by the English courts of Chancery from this supposed delegation of the authority of the Crown as parents patriae is more frequently exercised in this country by the courts of the states than by the courts of the United States.
Y'all hear this, y'all? Do y'all hear this?
Here, King.
Okay.
It is the state and not the federal government, except in the territories and the District of Columbia, which stands with reference to the persons and properties of infants in the situation of parens patriae. Accordingly, provision is made by law in all the states for the appointment of such guardians, whose duties and powers are carefully defined.
All right, one more. This right here.
The conception of equity's inherent original jurisdiction as a part of its general jurisprudence over the persons and estates of infants has general acceptance. While this jurisdiction may, in its very inception, have belonged to the king as a part of his executive power as parens patriae to protect his subjects, and may by him have been transferred to the Court of Chancery, it is firmly established as a judicial function of the court. It does not belong to the chancellor alone as the personal delegate and representative of the crown. It is exercised by all judges composing the Court of Chancery in the same manner and governed by the same regulations as all other confessedly judicial functions. Pomeroy's Equity Jurisprudence, 5th edition, section 1304. It has been suggested that by the ordinance of March 28, 1770, the governor of the province of New Jersey was left with all the jurisdiction held by the English chancellor as a judicial officer, as distinguished from his power as a minister of the king, or representing the king as parens patriae, and that the original jurisdiction of the Court of Chancery did not include the care of property of infants, a subject which belonged to the chancellor in England as parens patriae, rather than as a court, and was conferred upon the chancellor of New Jersey by statute.
Okay.
Okay.
Cool. And that's the district court judge Anthony Queasby. And he sat on the 6 presidents, y'all. 6 presidents. He's telling you that the king was obligated for the parens patriae, which he left it to the governor to be. And he had stopped doing that job. All right, let's come to our closing.
Mhm.
Read this, Countess Middleton.
A recent Washington State Appellate Court affirmed a trial court decision which found in favor of a property owner arguing that a common boundary was the real designation between adjacent owners of land as opposed to a legal description. The common grantor doctrine protects an original grantee acquiring property in good faith reliance on the boundary description provided by the common grantor, who originally owned both lots in their entirety, and thus had power to determine the location of the boundary. Even without a formal agreement, the boundary binds grantees if the land was sold and purchased with reference to the line, and the parties agreed about the identical tract of land transferred by the sale. The case stems from a property owner that sold 2 adjacent tracts of land at different times. A fence separated the 2 parcels of land. Both purchasers of the property bought the land and operated under the assumption that the fence was the boundary between parties. It was not until a year after a survey commissioned by one of the property owners and 3 years after the actual purchase of the lot did the property owner claim a dispute with respect to the property boundary. The court asserted that the parties operated under the assumption that the fence was the boundary between the parties, and it was clear that the fence provided notice to the subsequent purchasers.
Okay, so what we're trying to see here is that based off the law of contract, make sure I covered everything. 1 second. Let's see. Oh yeah, okay. So in closing, we all see, as Chief Justice Arthur Vanderbilt said, that we don't have to exhaust the remedy because that governed by the interstate commerce. We have to exhaust our remedy, which goes back to what we call a prerogative writ, which I'm gonna show you in a second. Just find it. This is me, parens patriae. Read that, Archbishop. See that?
Yep. Parens patriae is Latin for parent of the nation, and literally parent of one's country. In law, it refers to the public policy power of the state to intervene against an abusive or negligent parent, legal guardian, or informal caretaker, and to act as the parent of the child, individual, or animal who is in need of protection. For example, some children, incapacitated individuals, and disabled individuals lack parents who are able and willing to render adequate care, thus requiring state intervention. In the US litigation, parens patriae can be invoked by the state to create its standing to sue. The state declares itself to be suing on behalf of its people. For example, the Hart-Scott-Rodino Antitrust Improvement Act of 1976, underneath 15 U.S.C. 15, through the Section 4C of the Clayton Act, permits state attorneys general to bring parens patriae suits on behalf of those injured by violations of the Sherman Antitrust Act. Discussion. Parens patriae relates to a notion initially invoked by the King's Bench in the 16th century in the cases of non-compos mentis adults. The notion dates from at least 1608 as recorded in Coke's report of Calvin's case, wherein it is said that moral law, honora patrium, doubtless doth extend to him that is pater patriae. The parens patriae doctrine was eventually applied to children throughout the 17th to 18th centuries, and has since evolved from one granting absolute rights to the sovereign to one more associated with rights and obligations of the state and the courts towards children and incapacitated adults.
That's good. Okay, so as we can see, our rights has been transferred from our protection under the king, and the king is in his council to what we call the attorney general, and the council that was created by way of the government. So this is the reason why our case was brought forth, and let me just show you by way of what we call a writ. Let's show you a record. Somebody said something? Everybody see this?
Yes.
Yes.
This is the docket. Now, the case was removed, as you can see, the parties. They got King Clifford Jefferson, the individual, and defend the state of New Jersey as a business. Everybody see that?
Mhm.
Officer of the government. Somebody tell me, when did the officer of the government become a business?
Mm.
When? So that's a red flag right there. It's a business. Business is not a government, and government is not a business.
I mean, they always
Cody
tell us
Cooper-
business hours. So anytime you hear that term, business hours, it's a business.
It's a business. Versus me, King Clifford Jefferson, an individual. All right. Here's the docket. The motion was for judgment or writ of execution. You see the writ of judgment issue right here. 10-5. Motion to enter judgment uploaded by case manager by King Clifford Jefferson. The matter was stalled out. And as a result of that, I removed it to the district court because of the Administrative Procedure Act and Administrative Government, where they want me to exhaust my remedy in. And that was grounds for removal because of the diversity issue, which I pointed out in the district court. So now the matter was forwarded to Justice Georgetta Kastner, which was removed to another judge, Zanara Korish, right? This is another Chief Justice, where it still sits. Now, the docket didn't move in the district court until a final decision was given in the trial court for a reason for removal based off judicial relief. Because under Title 42 of the United States Code, Section 2000 CC, it clearly states that no government on the federal level, state level, municipal level, or any person acting under color law can impose a burden on a person, religious institution, or assembly, unless that government shows that it's compelling to the governmental interest or at least restricted to the governmental interest. And the only way that can be done is by one, the plaintiff or the private individual file a complaint, which I did. Second, you must meet your burden, which I did. Third, you must get judicial relief and a non-federal forum, which I'm seeking, because this is not a federal forum nor a state forum. This is an administrative forum, which I'll prove it to you in a second. If you come down here, all the way to docket, opposition to the motion submitted by Deputy Attorney General Sandell Thomas for the Jersey Department of Law and Public Safety. He was appointed by the Attorney General. The Attorney General was appointed by the governor. The Attorney General is head of the judiciary, in which this chief judge sits under, Judge Alvarez, as an administrative judge. Now, I've known that. That's why I removed it to the district court judge, where the docket still sits awaiting the trial judge's order, under this judge, which was scheduled on January 20th, 2023. Everybody see this?
Yes.
Let's go here first. Simon de Montfort. Simon de Montfort, can everybody see that?
See it, King.
Everybody see it?
Yep.
And read that first paragraph for me, Countess Middleton.
Simon de Montfort, 6th Earl of Leicester, sometimes referred to as Simon V de Montfort, to distinguish him from his namesake relatives, was a nobleman of French origin and a member of the English peerage, who led the baronial opposition to the rule of King Henry III of England, culminating in the Second Barons' War. Following his initial victories over royal forces, he became de facto ruler of the country and played a major role in the constitutional development of England.
Stop. Okay. Simon de Montfort was a rebel baron who went rogue against Henry III, son of John, son of Henry II, son of Godfrey V, Count of Anjou. When he went rogue because he broke away. This was the Second Barons' War. It was the first Baron War, then it was the Second Baron War. These barons went rogue, which was made up of the council members called the Knights of the Shire. The Knights of the Shire is nothing more than the community leaders coming together and being commissioned as a knight, right? As a knight, a holding office, pretty much like the House of Burgess. The House of Burgess is a title which goes back to the Virginia company called the House of Burgess, which was nothing more than community members coming together and create their own Congress, i.e. their own parliament, which is de facto parliament by way of the, what we call secret trade or secrets of the trade that they stole from England via our history. So the reason why I say this is to bring you here. Back to the order. Okay. You see the order, a prerogative, an order for judgment was issued. If you see here on January 13th, reply brief uploaded by case management established by King Clifford Jefferson. That's my prerogative writ. Writ of mandamus quo warranto and lieu of writ of execution for judgment for the defendant's failure to meet their burden, as well as to bring forth an opposition. The only reason for them dismissing the case based off this judge was based off this reason. A lack of prosecution, based off the reason I'm about to show you. But right after the judge dismissed it, he issued another order from the on the docket called lack of prosecution dismissal warning notice, not against me, but against the defendants, the state, because the defendants never answered this writ right here, January 13th. Prerogative writ, which the Supreme Court said it's the right, it's not a request, it's not a motion, it's a right. So at the day of the hearing, me and the wife was talking, Archbishop can validate, Brother Burgess, Brother Scott can validate, that before I went to court, my wife always told me, is there any way they can do to get out of this? And we must realize who we're talking to. We're talking to an administrative government with administrative officers and being upholding in administrative courts. So that's my argument. That was my writ. It wasn't nothing based off the original complaint. My argument was based off who are you? And I want to know why, because you're not complying to something that the Supreme Court said I had the right to. the trial court should have the right to file a writ against any administrative agency which you fit the description of. So you are obligated to answer this reply brief, which is a written matter called warrant, and in lieu of my motion for judgment. Now, mind you, the judge who's reviewing this, the defendants who he is reviewing is the Attorney General, his boss, and the governor, his boss. Does that make sense to everybody?
Yes.
So now, let's show you the order. Now, I told my queen, and I told Archbishop, I said, the only way I'm gonna get this off is to get them to admit their position under the Administrative Procedure Act, under the Civil Rights Act, because that's the only opposition that they brought forth. So the only thing I stated on the record is that they're obligated to answer this prerogative writ, because I know for a fact that their authority comes from under the Administrative Procedure Act, which imposes a burden as established under Title 42, United States Code Section 2000 CC. And it says that no government shall impose the burden unless they can show that it's compelling to the governmental interest. You're not a government. I showed you not a government.
Yep.
You're not, you are an agency and the business, because that's how you was docketed in the court. Now, the only thing I need you to do, if you're not gonna allow the state and the Attorney General to answer the prerogative writ, is that I ain't gonna say nothing else, because I'm not gonna sit there and oppose their justification, because what they're doing is fraud, and they got a whole bunch of case law to validate that. The only thing I'm gonna argue in this courtroom is why you as a judge is denying them the right to answer this prerogative writ, which the Supreme Court said you have to. It's not a request, it's not a motion. They have to answer this prerogative writ. But remember, he's playing an arbitrary judge based off the complaint submitted by a private citizen on behalf of the crown. Does that make sense to everybody? Does that make sense?
Yes.
I'm a private citizen, not no police officer, not a public citizen, or not a private citizen under their administrative government. I'm a private citizen under the crown, and I'm calling myself king. Why? Because parties may change, but the position don't, right? So the position of the king don't change no matter who's sitting there, because they still have a prerogative, and my prerogative is this writ that the Supreme Court not only said I have a right to follow. The New Jersey Rule 4:69-1 says I have the right to follow it, and I know I have the right to follow it because of this. Let's go to the Constitution of 1947 before I come to my closing. Article 6. Now, if the King Court is here and the Supreme Court validated that of the United States, and the Supreme Court of New Jersey validated that with a rule of the Supreme Court, oh, come on, give me 1 second, with a rule of the Supreme Court as well as case law. Here go, Article 6. Everybody see that?
Yes.
Read Article 6, Section 1 for me, Countess.
All right.
Read that.
Article 6, Judicial Section 1. The judicial power shall be vested in a Supreme Court, a Superior Court, county courts, and inferior courts of limited jurisdiction. The inferior courts and their jurisdiction may from time to time be established, altered, or abolished by law.
Okay, so everything that exists right now under the Judiciary Act is what we call inferior courts, because they're not lawfully Article 3 section courts, nor sanctioned by the Constitution, under the Constitution that preceded them. Why? Because of Section 4. Read Section 4. Right here.
Section 4. 1. There shall be a county court in each county, which shall have all the jurisdiction heretofore exercised by the Court of Common Pleas, Orphans Court, Court of Oyer and Termina, Court of Sessions, Court of Special Sessions, and such other jurisdiction consistent with this Constitution as may be conferred by law.
Okay, that's the King's Bench. Let's show how they transferred it. Article 10, schedule. Where's that? Schedule. I'm gonna come to my closing. Right here, section 3.
The Court of Errors and Appeals, the present Supreme Court, the Court of Chancery, the Prerogative Court, and the Circuit Courts shall be abolished when the judicial article of this Constitution takes effect, and all their jurisdiction, functions, powers, and duties shall be transferred to and divided between the new Supreme Court and the Superior Court, according as jurisdiction is vested in each of them under the Constitution.
Okay, so they transferred the King's authority by way of the 1947 Constitution and instituted it under the Administrative Procedure Act under their government for safekeeping until the King came back. So the Supreme Court can't exercise that authority, nor can the New Jersey Supreme Court exercise authority because it's only a prerogative of the King. And the Chief Justice said that only a private citizen can bring a private complaint and enforce the procedures of the Crown. The Crown can only be done by way of what we call a corporation sole, and that's how we were incorporated, as a corporation sole. So in closing, let's go to the docket. Read this in closing. Just read the ruling.
This matter comes before the court by way of motion to enter judgment filed by plaintiff, King Clifford Jefferson. This court, having reviewed all papers submitted and oral arguments set forth by counsel, for the reasons stated on the record and for good cause shown, it is on this 20th day of January 2023 ordered as follows. Ordered that plaintiff's motion is hereby denied for failure to comply with New Jersey Court Rules 4, Section 5-2 and 4, Section 6-4. And it is further ordered that plaintiff's complaint is hereby dismissed without prejudice against the state of New Jersey, for they are not a proper defendant under the New Jersey Civil Rights Act. And it is further ordered that if plaintiff chooses to refile his complaint, he must comply with the court rules and fairly apprise the adverse party of the claims and issues to be raised at trial. And it is further ordered that a copy of this order shall be served upon all counsel upon its upload to e-courts.
Okay, now what the judge did was give me my remedy, because he knew he could let down his bosses who are being sued, right? His boss can't answer the complaint. The only thing they said is that they're not proper defendants under the Civil Rights Act. So my question to them, which I knew it was, how in the hell you move from government to the Civil Rights Act? So I mean to tell me the government switched its authority from the Constitution to the Civil Rights Act of 1964? So you admitted everything that I wanted you to say. So now I can remove it to the district court because you just submitted in your order that you no longer follow the government, nor the Constitution, nor the statute. You follow the Civil Rights Act that deals with slaves. So everything that I told my wife, as well as Archbishop, that that's the only way that I can convince them or get a win is to get them to agree to the jurisdiction that they're under. And before I said it, before they did it, I said to the judge, this is what they're going to do. I said, I'm going to hold all my opposing arguments till the defendants argue the prerogative writ. If they don't answer the prerogative writ, the only reason why they're not going to answer it is that they're an administrative agency under the Administrative Procedure Act, because they're saying that the state can't be sued because they're not proper defendants of the New Jersey Civil Rights Act. First question is, how did you construe the king, Clifford Jefferson, to be under the Civil Rights Act? First of all, you can't put those two in the same sentences. You didn't say or disqualify me as being the king. My whole complaint is based off qualifying me being king. You didn't qualify, you didn't oppose any of that. You just simply said you want the judge to dismiss the case without prejudice. If your governor and your attorney general was who they say they are, why would you dismiss it out without prejudice? Why would you do that? If they were who they say they are, then you would dismiss it with prejudice. You didn't do it because you knew that you're going to get in trouble either way. And you told me the only way I can bring a complaint is filed under the Civil Rights Act. Well, what Civil Rights Act has to do with the Constitution? What does the Civil Rights Act have to do with government? Nothing at all. So if you disqualify or supersede yourself under the commission as established by the Constitution relative to government, and now made yourself commissioned by the Department of Civil Rights Act, which is an act that was created by a statute for events that dealt with a certain group of people under a certain classification who were qualified under the Administrative Procedure Act as their citizens. Why? Because the Attorney General is what? Foren's patriarch. And with that, I digress. Queen, you got the floor.
Another beautiful lesson from the king. I just want to give honors to him. His degree date passed on January the 14th. We didn't have class that day, but I want to just give honors to the king. Another beautiful lesson. We went over talked a little bit about attorney generals versus the governors and a meeting of the minds. William Patterson, we talked a little bit about the New Jersey Plan, the Great Compromise, Chief Justice Hughes, Simon D. Montfort, Ward versus Keenan. Another one was Flanagan versus Plainfield. But I just want to say today's lesson, it coincides with what's going on in the world today. And I always say there's no strange happenings. Everything happens in a timely fashion. And with everything that's going on today with our government that's being ran, and the way it's being ran is de facto. You have everything from police brutality, and you have these so-called senators being elected who should never have been elected. But it's just showing that everything is in a disarray. You have so many people who feel like they're not a part of society anymore because of the way things are being ran. We have a situation where me and the king are dealing with right now with a personal family matter where we feel like there's no real remedies being given to bring a resolution to the situation that he's going through right now. And I just want to say, that's because of the way that things are being ran right now. From families being, put in a stance where they don't know which way to turn. Our children being ran in a disarray, or being so-called the wards of the state. I just want to give honors to the king for trying to bring back the original common law of England. And that's where they went wrong, because we went astray from the original laws of the government and how things should be ran. And with that, I digress.
Well said, Queen.
Well said, Queen.
And that I like I said, you know, what she said is very important, because our sons don't have fathers. You know, our daughters don't have mothers. Neither of them have families. So they feel like they by themselves and forced to succumb to the very things that were put in society. And we reject them as a result of what society has put in for them to use at their disposal. And as the Queen said, none of it's beneficial, because you're at the mercy of the grantor. And everybody's getting something except us as a people. And it's hitting home now, and it's affecting me as a result of why I do what I do. So well said, Queen. And like I said, I'm have to take the spot of being the father, the mother, you know, the uncle, you know, somebody who to fill that gap to all these young brothers and sisters, or the older brothers and sisters who are homeless and are being looked down upon and don't have nobody to tell their story to, because nobody have time to listen. And then when you tell a story to them, they turn them, because, well, they had all these chances. What chance did I have when I got out? Because there's nothing here to assist me when I got out. We're forcing me to go back to the same situation. And that's what I need to fix. So well said, Queen. Archbishop, you got the floor.
Well, there you have it, brothers and sisters from the Kingdom of England, Empire of Albion, which you know today as Great Britain, lost within the so-called British American colonies. Our king has done a marvelous job once again in showing you what it is that we must do this day and age to fulfill a prophecy. And as he's showing you, those offices are positions that no matter who's in that chair, he needs to be fulfilling the role of what the duty and obligation of that official capacity is. And it's shown that those who are supposed to be trustees of our great estate have not been fulfilling their roles and duties and obligations, which have been placing us into the position that we're in today. And it's also too our fault, because we allowed it to happen based off of going astray and not doing what we're supposed to be doing to maintain our allegiance to our monarchy and keeping up the crown estate, which is now, like the Queen has said, has been in disarray for a very long time. And if you pay attention to what's going on in our waking world, or which we call the modern world today, you see that a lot of these ailments or plagues are actually coming to the forefront, just like the so-called scripture said was going to happen. We have one of the highest eviction rates, divorce rates, illiteracy rates, obesity rates. You think of it, and especially if it's bad, our people in the forefront leading it, and that's not a good thing. Like Yeshua said, he come for his own, and his own receive him not. And his own that he come for this day and age now is the English, because everyone knew that the English were and still is the chosen people, but they had to mix us up and put us into a state of mind where it's hard for us to actually be able to recognize who we are. And instead of actually accepting, like the king said, our official role, we choose to go astray and be something that's not us, which is causing us to have a lot of this mental illness that we're suffering or dealing with today. And as the king has been our pater familiae, or the head of the family, and we can say parens patriae, which is the father of the people, it is our honor and our duty for us to go ahead and pledge our allegiance back to our monarchy, so therefore we can see ourselves being saved in this day and age, because we come for many, and many, like I said, who get this message don't choose to actually honor it and do what's supposed to be done, because the conviction is not on their heart. So like we say here all the time here on the Third Temple English Church of England, it's better for you to not know this than to know this and not do anything with it. So that being said, we love you, and I digress, and I leave the rest of the closing to the rest of the panel. Peace and love.
Thank you. Thank you, Archbishop. Beautiful job letting the people know that this is not personal. This is not business. It's a calling.
It's a calling.
I'm commissioned to do this. So, I mean, people might think, well, you got to watch how you talk to people. That's the problem. You know, I'm going to talk to you how you need to be talked to.
Exactly.
So you can get what it is I'm telling you. So don't take it personal. You know, it's not personal. It's not business. It's what I'm called to do. So well said. Esquire, you got the floor, Noble.
Greetings, family. Can y'all hear me?
Yes, sir.
Yeah, I want to give praise to all of our martyrs and saints, King, Queen, and as well as the King bench right now. I understand what you're teaching us and telling us, King, about not understanding our history and how it ties into us, that we'll forever be circular.
Yes.
So I mean, you debunked all the dogmas. So I don't know what else to say, King. I'm really letting it digest them. I see exactly what you're telling us.
I really appreciate that. Like I said, you know, you can't hold an office until understanding what that office truly represents. And no one understands the office and what it represents till I came upon the scene. Till I came upon the scene. If it's been there and nobody's telling you, then that shows you their intent on behalf of the office.
Exactly.
Chief Justice told you that their intent was fraudulent. And the only person that could fix that was a private citizen, not one of theirs, but a private citizen under the crown. So well said. CA Code, you got the floor, Noble.
Greetings, peace and love. Yeah, marvelous delineation of statutory legislation and royal charters in conflict with the de facto corporate charters that are erroneously adjudicating the estate on behalf of the heirs. Their successorship has been explained under the 1947 Constitution, and that's where they derived their de facto letter patent or delegation of authority to administer land use and regulation upon the heirs. The heirs have claimed and positioned themselves in a position of restoration of church edifices, products, goods, services, and land. So we are here and we are visible, declaring and proclaiming, and now legislatively and putting in claims to restore our rightful lands and the use thereof. So yes, not enough can be said about the historical relevance of Pradean's Patriarch and how it relates to the delegation of authority from William Franklin on to Philip Murphy. So with all those who have the diligence to watch these lessons, study show oneself approved. You know, it's one thing to study, another thing to be disciplined and to actually apply the knowledge studied. So give high honors to all those who have the ability to apply this visible knowledge and, you know, use it as the King's consciousness for your birthright and or remedy to any particular claim or encumbrance that you may have. So, you know, it's so much that could be said. But it's a mastery of knowledge. You know, what we practice, we do a repetition, so you only get better with time. And I trust all those at the sound of my voice who are viewing this lesson are getting better with their education of all these facts. And I yield with that. Peace and love.
Thank you, Brother C.A. Code from the House of Murphy. And what's beautiful about this is that you'll never get a victory in their courts. But my victory came with the revealing of how their authority came. That's the conviction. That was the nail in the coffin for them in lieu of judicial review under the authority of a prerogative writ, because no one has the authority to issue prerogative writ, as Chief Justice said, is the highest judicial control and is used to mandate those who stray away from the supremacy, i.e. the law of the land. And we know that's the Constitution. So well said. Countess Middleton, you got the floor.
Yes, King. Very, very timely. So timely, it's kind of scary what you have been talking about. I was listening to you very carefully, and it really brings some insight into the times that we're ahead, and even some personal things that I know of that a person's going through. And it really can be overwhelming. And, you know, I am so glad that I've been listening to you and learning and studying. And I hope in my limited study that I can help to bring some remedy to, or at least some insight for those that are going against the court and really being really coming down. So I appreciate you. I've learned a lot. This is a very important lesson that I am drinking in, and I yield the floor.
Please said, Countess Middleton. And one thing I want everybody to focus on as I continue the narrative, to keep as my narrative. Parties may change, but positions don't. If you're going to be in the position of an English national, you have to be that. If you claim to be a member of the English Church of England, you have to be that. If you do either of the two, then you have to do the work. Because if I'm aware of what Chief Justice Vanderbilt and all the presidents that succeeded him all the way back to Viscount Cornbury, then I know where you at along the way. Because nothing is hidden. Nothing is hidden from you. So well said, those who spoke thus far, which brings me to the house of Brother Middleton from the House of Middleton. Greetings, Ross. And once again, Brother Middleton constantly reached out to me with what you call it? What's that? Maybe 1 second. What's Up Act. And he actually sent me 2 new things. One about showing that the government is being shut down, as well as showing one on the federal level, how they have initiated and have displayed us or the citizens as human chattel. So very good insight, Brother Middleton. I really appreciate that. But the first one you sent me about dealing with the government building shut down, that's not the first time I've seen that. I've seen this a couple of times. So we know TV is telling our vision. As a result of the heat is being brought on by our channel, especially with the one being instituted now, the government has told themselves, and majority of the citizens' due process rights come on under the Civil Rights Act. And the Civil Rights Act protects substantive rights, but it don't protect procedural rights. I'm gonna say it again. The Civil Rights Act protects substantive rights for bodies of the Constitution. What Constitution? 1947. But it does not protect procedural rights, because procedural rights under the 1947 Constitution comes up under administrative law, which goes back to the Civil Rights Act of 1964. Everybody follow?
Follow, okay.
Follow.
Okay, so with that, Brother Middleton, you got the floor.
Yes, King. You know, these are some mind-boggling lessons, you know.
Thank you, sir.
Unlike Ethel read the unready, you certainly read it.
Yes, sir.
Yeah, absolutely. Super qualified, King. Doing a real good job.
Thank you. Let me stop you. And what I like when you said that, because for me to say something in lieu of a court proceeding that ain't got here yet, And for it to go down exactly how I said it was going to go down is mind-boggling to myself. The state did exactly what I said they were going to do. I said they were going to admit on the record that they have no obligation to the Constitution, no obligation to the government, but they're following the Administrative Procedure Act, which I told them they were going to say before they even said it.
Wow.
And then I got the proof signed off by the judge, who I told him he was going to sign off on it. And the fact he dismissed without prejudice shows you he know what I'm talking about is true. Because if your God came in question, and because he created you, then you should have, then your judgment should have been in favor of your God without prejudice, with prejudice. I'm calling your God out, and you dismiss it without prejudice, and I'm calling myself king, and I'm saying I'm the king, and you dismiss it with prejudice. That shows you it's just a matter of time for their God to come into question. So what he was saying, king, what you saying is exactly right, but I have to make sure that I don't get myself in trouble, because I'm subject to be hanged by my creator, and my creator ain't even right. So to tell you, you gotta look at the word. It's power in word. So well said, Brother Militant from the House Militant. Continue on with your thing.
Yes. Anyway, I digress, King. You know.
Thank you, Noble. Thank you, Noble. And last but not least, Brother Cordell from the House of Cordell. He was there.
He was there. I think he's ended.
Okay. So with that, I really thank you all for being here today. The lesson entitled for this class is Parties may change, but positions don't. Parties may change, but positions don't. So if you're a party to this complaint, then that automatically means that you're an English national. If you're an English national, then you must play the position, and that's an heir. And the only way you can be an heir is to talk the language of an heir, and that's being the subject of that of the grantor. So you got to talk like me. And as of right now, I'm the only one talking like this. Y'all listening, and I'm talking. I need more talking than listening. Mm-hmm. And you can't talk it if you're not observing what you're listening. You hear me?
Clearly.
Yes.
Okay. So I love you all. Thank you for being here today. And once again, it's better for you to not know this than to know this and not follow it. And with that, I greet you as I meet you in peace and love. One.
Peace and love.
Bye-bye. Bye. All right.